So, by anyone. With civil cases, generally, you can quarantine data, or you can you can use certain tools that are available to you to quarantine data that keeps the metadata intact until you need to collect it. Or sometimes simply collecting the data is preserving the data. So, if you've got a company or an employee that you're getting ready to let go, and you were suspicious that they may have been stealing company secrets and there's some deleted stuff potentially on their computer, the best way to do it is just to make a forensic copy, because you're going to want to get at that deleted data. So you've preserved and you've collected at the same time. So there's not one right way to preserve. There are a few wrong ways. Don't just tell a company employee that, oh, hey, by the way, there's this litigation going on. Make sure that you just preserve all those emails. Because in their mind, they're going to think, well, as long as I just don't push the delete button, that should be good enough. And it's not. So make sure that you fully inform your party's clients or employees to understand the process of preservation, and make sure that they know who to ask questions to, so they follow through on their duties and obligations. And don't just assume that they know what they're doing, because at the end of the day, you're the one that's going to have to stand in front of the judge and say, Your Honor, I did this, and this, and we still lost some data. Or you're going to say, well, I told them to preserve. They should have known. Don't assume. I don't know why I didn't say this first. With data, this is probably the first phrase that I learned when I started working with Dan, is time is not your friend. The very moment that the triggering event happens, in your mind, you should immediately think to yourself, what do I need to preserve, and immediately get on top of it. The mere routine usage of a computer alters data, alters metadata. So make sure that you don't wait 6 months to say, maybe now's a good time to get that email off the system. It's a little too late. So think to yourself, in any case involving digital data, time is not your friend.
Now we're going to talk a little bit about spoliation. I have a general rule, and that's if a judge wants to talk about something, and in particular if a federal judge wants to talk about something, let them talk about it. So we're not going to talk a whole lot about spoliation at this time, just to reemphasize that spoliation can take place in many different forms. And one of the ways that you really actually, your clients can get in trouble with spoliation is with social media. You may have clients that have Facebook accounts or MySpace accounts, probably less likely now than before. They may have Instagram accounts, they may have Twitter accounts, they may have any number of accounts. And you can have them change their privacy settings so that the public can't see it. But what you can do is tell the client to erase posts or even to deactivate the account. Because there are ethics opinions out there that say that telling a client to deactivate or delete their social media account is intentional spoliation, and it can result in sanctions for both the client and for you. So make sure that you understand that. And also with regards to emails or data, if their information retention policy or their document retention policy is going to let stuff migrate off or delete very shortly, well, if it's going to be potentially relevant information, you need to make sure that they keep track of it, or else you can have an unintentional spoliation issue, or potentially an intentional spoliation issue. So just be cognizant of that as you're doing it. And the other thing that I would just emphasize is, with regards to the spoliation issue, you can't let information migrate off, because there's accessible and there's inaccessible data. And if you have data that's accessible that is about to migrate to inaccessible during the litigation process, if it migrates off, that is a cost that you're not going to be able to shift. Normally you're able to shift the cost of obtaining inaccessible media. Normally you're able to. But if you allow it to migrate off mid-litigation process, that's not a cost you're going to be able to recover.
And after scaring you guys to death about spoliation, sometimes lawyers' first response is, I'm just going to preserve everything. I mean, I don't want to spoliate something. I don't want to see sanctions. I'm just going to preserve everything. That's not the answer either, unfortunately. But going back to my favorite word of documentation, if you can provide a reason as to why you preserved this and you didn't preserve that, and it's a reasonably calculated, defensible idea, more than likely it's going to be upheld in the long run, especially if you can articulate why you didn't decide to preserve that. You're only required to preserve anything that's potentially relevant to the lawsuit. So take into account the case that you're working on and think to yourself, what's potentially relevant? And if it falls outside that scope, you've got a good reason to just leave it aside. But document it, and document why. Because you may think that you'll remember, but you work on so many different cases and you're so busy, and the next time that you get in front of the judge to talk about why you did that, might be 2 or 3 years down the road. And you might not remember why you made that decision. So make sure you document why, and then you'll have a reason. So spoliation isn't meant to scare you, but it's supposed to make you think a little bit more when you're making your decision. Collection. So I was making this slide, and I typed in the word collection, and the 1-800-COLLECT thing popped up, and I totally forgot about it in the 80s and early 90s. Hopefully someone remembers the 1-800-COLLECT commercials with Mr. T and Eva Save-A-Lot, save a couple bucks, and they hit you in the face. No? I'm the only one. Okay, well, I appreciated those commercials, and I thought, ironically enough, it was a bit pertinent. Save a couple bucks. Save a couple bucks or two if you dial 1-800-COLLECT. If you collect correctly, it's going to save you money. It's going to save your clients money. So in every case, consider your collection process. Think of your early case assessment. Think of, at the end of the day, throughout litigation, what you're hoping to achieve. Think about the ESI. What type of data is pertinent to this case? Is there deleted data out there that you need to preserve? If so, a bit-by-bit forensic collection is probably a good idea. Have you met with the other side yet before you're starting to collect? That might give you a direction as to how to collect. And what I mean by that is, if the other side says, you know what, we think that dating times are very important to this case. We think that between this date and this date, this happened with this data. And I want to make sure that when you collect that information, that metadata stays intact. Well, you now know that any way that I collect, I better keep that metadata intact. Otherwise, you're looking at spoliation. And there are tools out there that help quarantine that data and make sure that it's a forensically sound practice of collecting those documents or files, that you keep that background stuff that Bob was talking about intact, so you can respond effectively to those requests down the road.
Well, I just was going to mention one thing in regards to metadata, and it can be very important. There was actually an ethics opinion, I can't remember the name of it right now, but ethics opinion out of, thank you, Brian. There's an ethics opinion out of Iowa recently where metadata played a big role in whether or not an attorney was sanctioned. An attorney was going to file a document, but they let a date slip. And so they filed the document, but they predated it, and they basically forged the document and submitted it to the court, or submitted it to the other side. And the court eventually used the metadata of the original document to find out when the document was created. And they noticed that it was created after the date that the document was signed for. And they used that as a way to sanction the attorney for falsifying and fabricating data. And so, that's just a great example of how metadata can be used.
And I guess one thing that I forgot to mention earlier was whatever collection method that you choose, make sure that it's a legally defensible method. And what that means is similar to when you're bringing in an expert and they need to testify to reliability and the 3 R's of, and it's scientifically backed up. Use a process that you can repeat and show that it worked. At the end of the day, if the other side is arguing, well, I requested this, I didn't get it, they must not have preserved it. or they must not have collected it correctly. You want to be able to come back and say, you know what, just because you want this document to exist, it really doesn't, because I preserved it this way, I collected it this way, and it's just not there. So again, document and think about defensibility.
Now, with the next slide, the next section in the EDRM is it's a three-tiered process. It's process, review, and analysis. And a lot of the time when we're doing discovery, we mush this all together. And a lot of the time that's fine, because there are a lot of commonalities in that process, and a lot of the times you do them at the same time. However, it is important to a certain extent, but it depends. I mean, it can be very important, though, to keep those processes separate and to keep track of your hours and log those hours separately, depending on the phase that you're looking at, whether it's processing, review, or analysis. And the reason is that, Colleen took the clicker earlier because she said, I'm handling the clicker because you clicked your slides too fast, so I'm loving calling her out on that. Anyway, if you've got a situation, whether it's a discovery request to a party, or it's a Rule 45 subpoena, if you want to shift costs, and you're in a situation where you can shift costs, keeping track of the difference of these three phases is important, because the courts have, to a certain extent, consolidated around the rule that while the cost of processing data, or retrieving data, or searching for data, those are costs that can be shifted to the other side, you cannot typically shift the cost of doing the attorney review. And we'll talk about some ways that you can minimize costs about attorney review in a little bit, and some of the techniques that are emerging with regards to eDiscovery that you can use to minimize the cost to your client. But from the standpoint of caution, it is important to know and to keep track of the difference between when you're processing your discovery, provide it to the other side, whether you're reviewing that data for responsiveness or for privilege, and your analysis of that data, keep track of the difference, because that can be important.
All right, so, the first part that was on there is talking about the processing. And, if you're processing the data by yourself, you're not dealing with a whole lot of data, or if you're working with a vendor or an expert, think about the end goal. Think about what you're going to be wanting to find out at the end. What are you wanting to be able to produce to the other side? What have they requested? And that will help determine your methodology of processing that data. Because you need to process it correctly, so what you're reviewing is going to lead to the responsive information to their requests. So it is a bit of a process, but it's something to consider. Think forward before you come up with that plan. In the big data cases, the first part of processing is really whittling down the data, getting rid of the system information that's not user created. Making sure that the data is processed in a certain way that will aid your or your team's review of the information. And that could include, and it's basically reducing it by file type, data range, or deduplication. One of the things that I want to say about deduplication is, Bob and I had a long discussion about this the other day, and because I asked him, I kind of live in a dream world, working, on the outside of it, and not practicing on a day-to-day basis of understanding how it works. And I said, Bob, are there times where you're processing your own data, or are you going through it? And he said, oh yeah, certainly. And I said, well, let's talk about deduplication. And he said, okay. And so generally, if there's three of the same document, and I'll just produce the one. And I said, well, that makes perfect sense. And he knew where I was going with this, but we thought that it's important for you to understand that although a document may look the same on its face, the metadata behind it may tell a completely different story. So simply, thinking that you're pulling something down to be able to give to the other side, especially if they requested information that includes metadata. Be very careful deduping and getting rid of multiple documents that may have different information. So let's put it into context. Let's say a company's been accused of stealing trade secrets from another company, and they're trying to locate how, if they get that document and where it's at when they have it. Well, if the company has 10 employees and there's 10 computers and a file server, that document may be on the file server. It might be on every employee's computer. It may have shown up in 2007. I mean, it's going to tell a whole lot about where you're finding those different documents. So make sure that you're not inadvertently deleting responsive information, trying to, narrow it down and only have to produce, 350 documents rather than 400. Make sure you're intelligently deduping. And then I'm going to talk mostly about keyword searches because that's generally what we see come into our office in the smaller data cases. And one thing about that, if you are conversing with the other side and you haven't come up with a good plan, and you're thinking that you're going to have to put your search methodology or request in front of the judge, make sure you've talked to the vendor or the expert that's going to be doing the searching before you get an order in place. Because the hardest thing to do is basically go back in front of the judge and say, I wanted those 5 keyword searches, and now I want these 20 because I know a little bit more about what I want. I mean, you never want to have to go back in front of the judge multiple times to ask for something new. So, and what that does, if you haven't talked to the expert about what you want, you may unnecessarily box yourself in. You might be not affording yourself the opportunity to find the good stuff in the case because you've limited it to a certain date range, where you're using very common words that are going to have a lot of false positives, and at the end of the day, waste your client's money because the expert's filtering through a whole lot of information that's not even helpful for you. So ask for help, and they'll help you craft it, so hopefully in the long run they'll end up saving you money. And talking about keyword searches, who uses Westlaw or LexisNexis? Okay, that works pretty good, right? I mean, you type in the word, it usually produces what you're looking for. Keyword searches on, forensically sound documents don't work that well. And the reason why is because people are terrible spellers. So if you are assuming that you're going to use this really awesome keyword that is very specific to the case, it's a trademark, or it's a chemical in science or biology or something along those lines, more than likely someone's misspelled it. And they put it in the title, and all of a sudden we run that keyword search specific to that, and it misses an entire string of emails of them talking about stealing the formula for that program. So when you're thinking about keyword searches, keep an open mind of how to formulate them. Let's see. At that point, though, especially now that we're seeing bigger cases, after you've done keyword searches and you get a couple of documents to review, that might be easy. But we're reaching a point, and I'm sure you've heard about technology-assisted review and computer-assisted review and all these other phrases. We're realizing that linear review, or reviewing every single document, may no longer be possible just because of time and cost. So that's what we'll move on to.
Yeah, we'll talk about that in a second, and then if you go back to the previous line, there's one other item that we sort of need to discuss. We talk about technology-assisted review. There are a bunch of ways to do it. Some folks refer to it as TAR, there's technology-assisted review, there's computer-assisted review, there's also one of the phrases that I like, and one of the technologies I actually really like, is called relativity assisted review. And what that is it is a computer system, it's a computer software you can purchase out there, and it's actually something that's kind of cool when you've got a really huge case. And you can do this either on the production side, or if you agree on the Form 52 to use relativity assisted review, you can do that. You obviously have to do that up front. You have to discuss whether or not you're going to use that. But it's a process where it's sort of magical as far as I'm concerned. I don't actually understand completely how it works. The folks are a lot smarter than me that created it. And so what you do is you get documents and they come through. The system provides you documents. You say, yes, this is responsive. No, this is not responsive. Yes, this is responsive. No, this is not responsive. And there are different ways that they do it because there's different vendors that do it. But and the system learns what's a responsive document. And so, as you say, whether it's a responsive document, it learns what is a responsive document. And it eventually just produces based off of what you've said is a responsive document. And so it can be very helpful, both either from a production standpoint or from a review standpoint. There are other methodologies like sampling and whatnot. And the one thing that I also want to talk about is here we have this item called indexing here. Now, indexing, it may seem all technical, but I think we've all used indexing before. How many of you have used base names? Yeah, you did those. So, but there are other types of indexing that you can use. And indexing can change based off of the type of data that you're producing. You know, a lot of us produce our data in PDF or paper form, which is also known as quasi-paper from an eDiscovery standpoint. But if you agree at the 26 conference to produce things in native format, then you may not be able to use a base stamp indexing. And there are other ways that you can do it. There's another methodology called hashing. You can create hashes for the data, and that creates identifiers for a document based off of an algorithm that looks at the data internal to the document. But that's something that we can do. I see we're running out of time, so we are going to start speeding up a little bit faster. So, when you do your review, you've got to obviously review it for privilege, and you know that is something. And you know we all probably use non-indexes or privilege indexes or privilege logs. You know those are important because you know the case law is pretty consistent that if you assert privilege, but you fail to provide a privilege log, you effectively waive the privilege. So that's why that's really important. And the real reason why I want to talk about this is when you have huge data cases, big data cases, it may be ludicrously expensive for you as the responding party to review all of those documents yourself. And in big data cases, and in any case, inadvertent disclosure of privileged materials can happen. And so how do you combat that? Well, one of the common tools, and increasingly it's considered generally malpractice not to have some sort of clawback agreement, which says inadvertent production of privileged materials does not waive the privilege. And so either include that in some sort of protection agreement, or protection order, or just have it as a part of your Form 52 report. You know, if you're in state court, get some sort of agreement put up before the court so that you can get that taken care of. Now, the next is called the quick peek agreement. And, you know, that's, Judge Scheinman does a very good job of saying what a quick peek agreement is, but you'll also see in the case law, it alternatively referred to as a clawback agreement. So, it can be a little confusing, because a clawback agreement can refer to both an inadvertent production, but it can also refer to a quick peek agreement. And what a quick peek agreement is rather than the responding party doing the searches, doing all the querying, doing all the review, they turn all of the data over to the other side. And the other side then takes on the cost themselves of searching through that data to find responsive documents. And then once those responsive documents are found, then there can be a discussion or objections as to privilege for many of those documents by the other side. And then you have to